performances fit in with the trial at the end in terms of the weight accorded to those weekly performances. And as I think we mentioned in the first class, we don't want you to be overly obsessed with the weekly performance in terms of getting a grade, because there is no exact mathematical calculation that's being made from week to week. What the adjuncts are going to be looking for are two things: how prepared you are and what kind of progress are you making from week to week. And they will keep rough logs based on those performance sheets of what you're doing from week to week. But they're not going to give you an A or B or whatever for that week's performance. This is not a contest to see who is the best trial advocate. It's not graded that way. We're looking for the foundational elements of effective advocacy, which are preparation and progression from week to week. So where do these weekly performances fit in? They are absolutely critical, and they will factor into your final grade. The bulk of your final grade is going to be driven by the trial, the final trial, where you're bringing everything that you've learned together. So much like a final exam. However, the weekly performances will be factored into and reconciled with your final trial performance to come up with a grade, right? Now, the reason those performances are so important, in addition to your development, is because they're going to give the adjuncts a pretty good idea of your development and your performance in the course overall. They're going to have a pretty good snapshot of you before you even do your final trial. So obviously, those weekly performances are going to influence their perception of you going into the final trial and will inevitably color their assessment of your performance in the final trial, right? So if you're doing really well, you're building up week to week, you're progressing, you're always prepared, and then you fall flat on your face in the final trial because you just didn't prepare enough, that inevitably is going to affect how they calculate what they think is the final assessment in terms of a grade. So, first impressions are the most important. And so these weekly performances are very important to create the most favorable impression in light of those two objectives, preparation and advancement from week to week, in the minds of the persons who are ultimately going to judge you. Okay, so it factors into it, not with any mathematical exactitude, but it definitely influences the outcome. So you want to make sure that you do what you have to do in the weekly performances. Okay, any questions on that, or Professor Cialino, you have anything you want to add to that? Okay. Now, I know some of you may not have gotten as much feedback as you would have liked last week, but, it was the first exercise. It was storytelling. There was a lot on the agenda. It was a struggle just to complete the rotation so that everybody got up there, twice or whatever. And so the adjuncts may have been a little hard-pressed to give you, as much feedback as you wanted on every one of those. But as we go into the more substantive exercises, like starting next week with opening statements, you will be getting concurrent critiques. I've got an opening statement. Obviously, after you finish your opening statement, you should get immediate feedback. When you're doing direct examination, you may actually get feedback in the course of your direct examination, etc. It just depends on what the exercise is. Okay? So let's talk about case theory. Much of what I'm going to talk about today comes from a couple of sources. One is Trial Practice by Martin Radvanec, Dubin, and Guernsey. It's a very good alternative how-to trial manual. And the other comes from, when we get to opening statements, from the art and science of trial advocacy. So these are just some of the better principles that I've come across in reading a variety of these sort of how-to trial manuals. So, case theory. Case theory is really what happened and why you should win the case. We talked about a trial being a contest of competing narratives. Competing narratives of the events that led to the lawsuit. So your case theory should encompass your client's version of what happened within the framework of the facts and whatever the governing law is on that case. So in order to be persuasive, your case theory has to be, first of all, concise, it has to be clear, and it has to, most importantly, accord with common sense. It's got to pass the common sense test. What do we mean by common sense? Common sense as it is defined by communal values, common values, belief systems, customs within the community. That's why it's very important to understand the customs of the community from which that jury pool is being drawn, if those customs particularly relate to the issues in the case. So, whether it's a judge or a jury, the common sense factor is going to weigh heavily in the efficacy of your case theory. It's also important to not only say what happened and why you should win the case, but also for its persuasiveness, you have to explain why things unfolded the way they did. Not all the facts are going to be favorable to your side. There are going to be some undisputed facts, but there are also going to be disputed facts that are going to require an explanation on your part of why your client was motivated to behave as he did, right? If you're representing a defendant in the case file, Andrew Parker, or the employee of the defendant, Americraft, Andrew Parker, you've got some explaining to do, right? There are a lot of facts, some of which are undisputed, that suggest he was a womanizing, philandering guy who was trying to score a date with a hot babe, which he did, at which date he consumed alcohol, and which led to a series of careless decision-making on his part, culminating into his running into a motorcycle of Jackie Fulbright and ruining Jackie's life. So you've got a little bit of explaining to do in terms of what was actually going through Andrew Parker's decision-making process that day. Was he this womanizing philanderer who was just trying to get a date with Kim Anderson, or was he the hard-working salesman who was rewarding the gatekeeper to his most important client, upon which his company was dependent upon 20% of its sales revenue, right? So that's just a, just a slight example of explaining the motivations of your clients and your client's explanation of the event, especially with respect to the disputed facts. So, in short, case theory is, this is what happened, folks, and this is why you should rule in my client's favor, why you should win. Okay, so a strong case theory, along with very thorough investigation and very good witness preparation and effective communication skills, is usually the determining factor in a close case. Who wins a close case? So the case theory is critical to that outcome. It really is that simple. So you have to choose your case theory early in the case, and it is going to evolve. It's going to change as you start inquiring of your client and other witnesses facts that are important to developing whatever that theory is. But it is a work in progress, right? It's got to be done before discovery is completed, because the discovery is going to yield the bricks and mortar that's going to put your case theory structure together in the most persuasive manner possible. So it's the very first step to good case planning. It's going to start with that initial client interview. It's going to continue through your inquiries of the client. It's going to continue as you draft your pleadings, as you construct your motions, engage in your discovery practice, and your trial preparation, and ultimately the trial itself, where it culminates at the beginning of the trial, actually, with your opening statement. That's your first chance to introduce this case theory that you've been building from the day that that client walks into your office and you decide to take the case. Okay? So, needless to say, it's very important. Effective case theories win close cases. Now, you also need to understand your opponent's case theory. That's equally important. You have to anticipate what your opponent's case theory is going to be, and you have to understand that so that you will be able to seek the appropriate pretrial discovery of various facts that are going to defeat, weaken, undermine, or completely refute the case theory of your opponent, right? So it's going to allow you to, by anticipating your opponent's case theory, it's going to allow you to refute that theory in your pleadings, in your opening statements, throughout the course of your examinations, and in the closing argument itself. So just keep in mind that a strong rebuttal can be devastating to the other side's case. So as you're constructing your case theory, don't forget the other side of the coin. Anticipate what the other side is going to come up with, and build your case accordingly. Now, let me just give you another example on, we'll use the defendant's side again, with Andrew Parker, since we've already thrown that out, right? Hotshot salesman, one of his biggest clients is the secretary for one of his company's biggest clients is Kim Anderson. Now, he's saying, this was a business lunch, nothing more. I'm a happily married guy, I've got 2 loving children. I've never been unfaithful to my wife, right? That's going to be his spiel, right? He's also going to say, look, this is how it works in the sales game, right? You've got to reward the people who are going to give you access to the decision maker. Oftentimes that's secretaries or personal assistants. And you've got to take care of these people. And the way we take care of these people is that we frequently take them out to lunch, give them small gifts. It's not only effective best practices, it's actually encouraged by my bosses, right? So that's what I was doing that day, right? And I take great umbrage at the suggestion that it was anything else. You know how it goes. Well, that's all well and good, Mr. Andrew Parker, but isn't it a fact that you asked Miss Anderson out on several dinner dates? Dinner dates, not lunches, and she refused. Isn't it a fact, Mr. Parker, that you actually had 2 martinis at this so-called business lunch in the middle of a hot August afternoon? Isn't that right, Mr. Parker? Isn't it also true, Mr. Parker, that you were so enthralled with your finally being able to go out with Miss Anderson that you told the doorman after lunch that you just had lunch with a hot babe? Those are your words, aren't they, Mr. Parker? So that's an example, just a small example of anticipating what the theory of the other side is. It's a rather obvious theory, I would think, that you would anticipate as far as explaining what Mr. Parker was doing on that date with Miss Anderson, right? So just an example of the importance of understanding your opponent's theory as well. Now, formulating your case theory. Let's see if I can keep this current with what I want to talk about. I told you, formulate it early, revise it as necessary. You're going to discover facts through the course of discovery. Some are not going to be particularly conducive to your theory, so your theory may require some adjustment. So formulate it early, revise as necessary. Know the law. Sometimes we think of trials only in terms of the most compelling story, the ethos of the gladiators, the attorneys, the pathos of the victim's story, right? But we forget about one very important thing, the law, right? You gotta know the elements of every claim and every defense, and you've got to come forth with sufficient evidence to sustain your burden of proof, your burden of production of proof on each and one of those elements. So your case theory has to be developed with the legal principles that govern your case in mind, understanding the elements of each of those claims and defenses. And your theory has to be consistent with the prima facie elements of those claims and defenses, right? So, however great a case theory you may have, it is going to be pretty useless if it's dependent solely upon facts that you cannot prove without corroborating evidence to support your theory. And what's going to happen is going to be dismissed at some early dispositive stage. Might be a judgment on the pleadings, it might be summary judgment, but you risk having the case dismissed at an early juncture because you haven't given adequate attention to the law. Now this is a pretty straightforward case. It's a negligence case, right? It's duty, breach, causation, damages. There's some serious issues regarding causation. What caused Jackie's epilepsy? Was it the motorcycle accident, or was it a violent hit that he suffered at football practice? So causation figures prominently here, right? Negligence also involves a breach of duty, right? A lack of reasonable care. So there are lots of issues about, did he have 2 martinis or did he have a wine spritzer? Those are disputed facts, right? Did he take adequate precautions before he pulled out into the path of oncoming traffic? You know, did he check his rear view mirror, side view mirror, move out slowly, make sure visually checking that there was no oncoming traffic? Or was he so taken with looking at Kim Anderson's rear end as she was going to her parked car, feeling the effects of 2 martinis, that he forgot to take those reasonable precautions, right? So, you know, that's, you know, another example of making sure that you understand what the legal requirements are for your for each of the elements of each claim and each defense. So now, I have up here, keep it simple and use common sense. That's sometimes easier said than done, especially in a complicated case. If you have a complicated antitrust case, it's sometimes, you know, difficult to corral those complex legal and necessarily complicated factual underpinnings of those kinds of claims in a simple and concise way. But you've got to make sure that you boil it down to its essence and that it comports with common sense. Because if it's too complicated, the jury's not going to understand it. And they're not going to bother to try to understand it if you present it to them in a way that's overly complicated. So try to keep it to a paragraph or 2, right? Now you might consider having a short version or a long version of your case theory. You would use a short version, for example, in preliminary conferences with the judge, and you might use a longer version in settlement conferences or pretrial motion conferences. But whatever version you're using, it has to be internally consistent. And each point in your case theory has to flow logically from one point to the next point so that the conclusion inevitably flows from those prior points. Right? So let common sense be your guide. The fact finder is going to be, whether it's a judge or a jury, is going to be using their own life experiences as a reference point to see if what you are claiming actually makes sense from their perspective. So keep it simple and use common sense. Keep it consistent. Now, alternative theories, sometimes it's unavoidable, but just keep in mind that when you are presenting alternative theories to the jury, you risk confusing them. On the defendant's side, in this case, it's particularly problematic because you almost have to present alternative theories, right? One theory is, look, if he got epilepsy from a traumatic hit, it's his own fault, his own contributory negligence. He didn't strap his motorcycle helmet on. He was riding down the street not at an excessive rate of speed, well beyond the speed limit, waving to passers-by along the way. He was a young kid, probably fearless, probably thought he was invincible, but unfortunately, that improvident decision-making is the cause of the ensuing accident, and not anything that Mr. Parker did or failed to do. It was Jackie Fulbright's own decision-making and his own lack of reasonable care that caused his dilemma. But then you gotta go into a massive however of sorts, right? However, the medical evidence will prove that it was not the motorcycle hit that actually caused his epilepsy, but rather a violent hit he suffered at football practice where he said he got his bell rung. Those are Jackie's own words. And it was that very night, after that hit, that he suffered his first epileptic seizure. As contrasted with a motorcycle helmet where he didn't even have an abrasion, but was released from the hospital, given some aspirin the very same day, and after tests determined that there was no injury that required further treatment. So you see the inconsistency there, but you see the propensity to confuse as well. So you have to, if you're on the defendant's side, figure out a way to reconcile those alternative theories. One theory of the defense is contributory negligence, the other deals with causation, right? And they are conflicting. Did you have a question?
Answer my question.
Okay. But generally speaking, try to keep your case theory consistent internally, if you can. All right, use admissible corroborating evidence. This may seem like an obvious thing, but it's critical to persuading jurors about your client's version of events that you present corroborating evidence that is going to confirm what the witness is saying, the important witnesses, like the Jackie Fulbright or the Andrew Parker, right? So you have to analyze somewhat critically the documents that you're going to use and the exhibits that you're going to use to confirm or corroborate that testimony. But again, it's not going to do any good if it's not admissible. So you need to understand the evidentiary foundations for the admissibility of that evidence to corroborate the testimony. Trials often come down to credibility determinations. So much of what you do at trial is going to ride on, in terms of its efficacy, whether or not you've been able to adduce sufficient corroborative information to substantiate what the important witnesses are telling the jury. Okay, got to have both. You can't just have a testimony. All right, now, so you want to go through the rest of this a little quickly. Assess your strengths and weaknesses. Needless to say, you want to emphasize your strengths throughout the trial, and especially in your opening statement. But you're going to reiterate those strengths throughout your direct examinations and even in your cross-examinations and certainly in your summation. But it's also important that you determine your weaknesses and you deal with them up front, because you can't just ignore them and pretend they don't exist, right? Why not? Because the other side is certainly going to spotlight those weaknesses. And then the jury is going to begin to think that you're holding back, that you're not the truth giver, because you didn't address an obvious deficiency in your case that requires some sort of explanation. But it doesn't mean you put it up front in lights. It can come after your strong opening remarks in your opening statement, right? Perhaps buried in a although clause, right? For example, dealing with Jackie's being hit and getting his bell rung at practice. You gotta come clean with that, right? Best to probably come clean with it in your opening statement. The defense is going to tell you that Jackie's epilepsy was caused by getting his bell rung at practice. Although Jackie did get hit at practice, it was like any other hit he had had time and time again without any complicating consequences. He was in football gear. It is a contact sport. Jackie's been through such hits time and again without any traumatic medical result. So, but you've got to come clean with it. Now you don't want to start with that, but it's just an example of how you can sort of deal with it with a yes, but, or although this happened, let me tell you why it's not important in this case and why it's not determinative of the outcome. So, good lawyers, they will neutralize weaknesses, or even in some cases turn them into strengths. Can sometimes do that as well. Now, sequence and emphasize strategically. What does that mean? Well, organization of your case theory is going to be guided primarily by logic, but there is oftentimes room for what I call artful sequencing. So if you think about it like building a fire, right? If you're building a fire, you start with your most combustible wood, your driest wood, the one that's likely to catch fire immediately, right? Using that analogy in your case theory, you're going to want to do the same thing. You're going to want to grab the juror's attention as quickly as you possibly can with efficient, tight, impactful language, right? Let's just take a case, for example, if you're doing an opening statement and your case theory is that greed destroys, right? You don't want to say this case is about greed. You don't need the clutter of this case is about. You could start with greed destroys. It destroys lives. It destroys relationships. It destroys everything it encounters. In this case, you see the greed of the defendant sitting right over there, who destroyed the lives of millions of investors whose money was entrusted for safekeeping and investment with him. And those lives were destroyed by the greed of the defendant in his deceptive and ultimately fraudulent investment practices, or something to that effect. So my point is, start strong. Capture their attention as early as possible with your case theory. And take the moral high ground and emphasize the opposing party's wrongdoing. There should be a strong undercurrent that your client was in the right. Why? Because jurors want to compensate a victim, someone who's been wronged. And they also want to make the wrongdoer pay, right? So that it's much easier for them to choose one side over the other if they think someone has been wrong. So it's important to develop that pathos on behalf of your client in your case theory. All right. So can we just switch to opening statements? I hope I haven't gone on too long here. I think we're coming right under the wire with opening statements. I have to go a little quicker than I wanted to, but while she's getting a slide on opening statements, let me just tell you that opening statements, they win cases. Most jurors, if it's a jury trial, jurors, and I think, to the extent that a judge will allow you to make an opening statement in a judge-only trial, usually they'll say we can dispense with that. But whoever the decision maker is, they make up their mind at the earliest juncture possible, and usually that is in the opening statement. So the opening statement gives you a chance to provide the jury or the judge with an overview of the trial to come. But it's very important that you understand who your audience is when you're giving an opening statement, and I'm talking jury trials here, right? So there are a number of reasons that opening statements can be ineffective and weak, and oftentimes it's because the advocate doesn't understand who the audience is, right? First of all, jurors don't want to be there, right? They're taken from their jobs, from their families, they're getting paid nothing, next to nothing, and they're not exactly happy, right? So you've got a captive audience that doesn't want to be there. So that's a hurdle in and of itself. Secondly, you're a lawyer. Lawyers don't have the best reputations in society, right? So, you're doing pretty well if by the end of the trial, the jury's gotten to know you and maybe even like you, or even trust you. That's the objective, right? But don't count on that at the very beginning, because there's going to be resistance in just trusting lawyers in general. So that's another hurdle. But and I'm not saying these are insurmountable, it's just you need to keep that in mind in how you present your case. Another hurdle is that jurors, they don't want to be there, but they also have a lot of other stuff on their mind. They're thinking about what they're missing at work, the commissions they're not making, their children who are not going to see their father or mother after school, missing the important first baseball game. They're going to be thinking through all of those things. And so capturing their attention, holding their attention, you got to keep that in mind, which is why, grabbing them at the outset without wasted words is very, very important. And then finally, jurors, like most of us, or many of us, we get a lot of our information from passive sources like television or Google, right? Which force feeds us the information. So our attention span as a result is not very lasting. You got to keep that in mind in crafting your opening statement. I think about it, even you watch a sporting event. You're watching it, but you got the color commentator, you got the play-by-play guy, you got all the stuff going on with the ticker tape underneath, and then you're probably changing between channels during commercials, right? Attention spans are increasingly shorter in this information age of ours. So, you don't have a whole lot of time to grab this jury. So you've got to make the most of it with economy of expression using impactful words. So, it's very important that you keep that in mind, who your audience is. Okay, so how do you get over some of those hurdles? What are some things that you should consider? These are principles of opening statements that derive largely from the art and science of trial advocacy, which is, I think, a particularly effective how-to trial manual. I think there are copies of it in the library. But okay, let's start with principles of opening statement. First one here is no wind-up, no throat clearing, no trying to calm your nerves by inane comments, joke-telling, current events. Most people give speeches, why do they always start with current events or a joke or some brief bio of themselves. Those are just efforts to break the ice and to calm their nerves, frankly. Because, most public speaking, there's a little bit of nervousness going on. Sometimes there's a lot of nervousness. So the speech giver uses those little techniques to kind of ease into the substance of the speech. Don't do that in your opening statement. Lawyers frequently do the same thing for the very same reason. A couple of the most egregious offenses in that regard is, the first one is explaining what an opening statement is. An opening statement is this is what we lawyers call an opening statement, right? First of all, It ain't just lawyers that call it an opening statement. Everyone calls it an opening statement. And frankly, this is not some insider knowledge, which is somewhat condescending to say, but let me break it down to you, boys and girls. This is called an opening statement. In addition to being condescending, you're wasting precious time. This is your first opportunity to get the attention of this group of people who don't want to be there, who are probably pissed, who have the attention span of a gnat, and who want to get out of there as quickly as possible, right? So don't say something like the opening statement is like a roadmap, or the opening statement is like a picture on the cover of a jigsaw puzzle, or any of that inane foolishness, okay? That's number one. Number two is don't give a civics lesson, right? I want to start by thanking you for your service today, you know, fulfilling your civic-minded obligation to serve on a duty, on a jury. There's a time to thank the jury, but it comes at the end of the trial, not at the beginning of the trial. And also, with respect to civics lessons, don't go into, you know, the jury is the foundation of our democracy. And it's important to a democratic society that we have folks like you. You know, don't do a civics lesson in that regard, and then quote Abraham Lincoln or somebody like that, okay? So don't do that. Don't thank the jury for their service. As I said a minute ago, there's a time for thanking them for doing what they're doing, but that comes at the end. And don't diminish the evidentiary value of your opening statement by saying something like, what lawyers say during the opening statement is not evidence. So what I say and what the defense lawyer says is not evidence for you to consider in deciding this case. Now, you may as well tell them, just ignore me and what I'm going to say for the next 15 minutes because it's just not important, right? Well, why would you do that? I never understood why anyone would do that, but anyway. So don't explain what it is, don't give a civics lesson, don't thank them, and don't tell them what you're saying is not evidence, okay? Also, don't characterize your case with these simplistic generalizations like, this is a simple case, this is a complicated case, this is a distasteful case, distasteful case. Just tell the jury what the case is about without describing it in those generalized terms. So, no throat clearing or wind-up. Okay, use pictures, lists, timelines, and exhibits to the extent practicable. However eloquent you may be and however logical your opening statement is, you're still swimming upstream against retention, right? That they remember at least the most important parts of your opening statement. And one way to effectively assure the most retention is to supplement your opening with some sensory aid, right? It might be an exhibit, it might be a diagram. For example, the diagram of the street in the restaurant that Andrew Parker was pulling out of and the lane of traffic of the oncoming motorcycle. That's difficult, if not very difficult, to describe just orally. But a picture's worth 1,000 words, right? It also makes it easier for you to explain with economy of expression because the diagram is assisting you. Resist the temptation to be overly technological, you know, not have a PowerPoint slide for everything that's coming out of your mouth. That's going to dilute, that's going to have the opposite effects. It's going to, I think, dilute the impact of what you're saying. Sometimes the simplest aid is just walking up to a chalkboard or a dry erase board and listing 3 or 4 of the most important points in your case. It can be very, very effective. But think about supplementing what you're saying in your opening with pictures, exhibits, lists, timelines, etc. Let's see, we're doing okay for time, but let me just make sure and speed up a little bit. Avoid unnecessary clutter and detail, right? it's not gonna do any good to say that, you know, on August 1st, you know, whatever, at 3 p.m., the plaintiff went into Mr. Green's auto shop and about too much detail. It would be better to say 2 weeks before the accident, plaintiff went into the defendant's shop, right? Dates and times at that early juncture is not going to be meaningful. So you don't want to unnecessarily clutter your opening with those kinds of detailed, descriptive components, right? Also, directions are much easier if they're shown rather than referred to as the westbound Chevrolet, you know, collided with the northbound Cadillac at the intersection of blankety blank. Got a diagram, you can refer to who's going where, and they can see it, and it unfolds in a more visually stimulating and likely to be retained format. Okay, so avoid unnecessary clutter and detail. Avoid promising too much. This is hard. This is really hard because it is an adversarial exercise. You want to win. You've got to win, right? Your client, this is the most important event in your client's life at that moment. They may have property or their freedom at stake, right? So the idea is to win the case, and sometimes in the zeal to win the case, you may give in to the temptation to exaggerate. Spin the facts a little bit too much. Try to avoid or try to resist that temptation. Now, that's easier said than done, right? Because you have the strong case theory that you've enveloped in a very effective story. You're ready to present that to the jury at the opening statement in order to win at that juncture of the case, to have them make a decision at that point. Because when you finish your opening statement, the jury should be like, there's only one way this can go, or should go, right? That's the objective of the opening statement. So the tendency is to maybe exaggerate a little bit too much, and you know, that's fraught with danger, because you don't know what the witnesses necessarily would testify, no matter how well you prepared them. You don't know what testimony will be admissible or what exhibits will be admissible. You don't know if the proof that you are presenting is going to actually establish the claims. So you've got to be a little judicious in not over-promising. Because if you promise something in an opening statement and it doesn't manifest in the trial, you can bet your opponent's going to be the first thing they say in closing argument. Remember plaintiff's counsel, when they told you, we will prove such and such? You never heard anything about that, did you? So, is what plaintiff's counsel told you at the beginning of this case to be believed? When you saw throughout the course of this trial several instances where those were just empty words. Okay, so don't overpromise, resist that temptation. Never waive or reserve the opening. It's a little bit weird because you can waive your right to give an opening statement altogether, and defendants can defer their opening statement until after the plaintiff or the prosecutors put on their case. Neither of those options is a good option to take. Never, ever, ever waive it, right? Most jurors make up their minds in opening statements, and you will likely have lost the case if you let your opponent's opening go unchallenged and unmet with a competing narrative of the events, right? It's just human nature. So don't waive it, and don't, if you're a defendant, defer it till later on. Because later on may be too late too, right? The jury will likely have aligned themselves with the plaintiff so that when you finally give your opening, if you waited till after the plaintiff has put on their case, it may be too late. It may fall on deaf ears, or you're certainly going to have a much, much harder persuasive hurdle to get over. All right, just trying to keep track of the time. We've got 4 minutes. Where to stand, where to look, where to go, what to do with your hands. Professor Cialino has covered a lot of that. But where to stand, you have several options. You know, you could stand behind the podium, and you're required to stand behind the podium in some courts, in the federal court namely. You know, in between counsel table. Another option would be, if it's allowed by that particular judge, is to stand in front of the jury. Again, behind a podium, you know, with the podium parallel to the jury or right in front of the jury, or just stand right in front of the jury without any barrier. In most scenarios, that would be the preferable one, because it eliminates a barrier between you and the jury, right? The podium is a physical barrier. You know, it's something that inhibits your connection with the jury. So, if possible, and if it's within your litigation persona, because it just may not be in the cards for you, you may actually be more effective behind the podium. But more often than not, getting away from the podium is going to be more persuasive. Where to look? Look the jurors in the eyes. Right? Truth givers look someone in the eyes when they're trying to persuade, because it connotes authenticity. It connotes that you don't have anything to hide, because you're looking in their eyes, and that gives a certain credibility, authenticity, and believability in what you're saying. You are so sure that your version of the facts is the truth, that you're communicating that confidence with your eye contact with the jurors. Now, I think Professor Cialino in his lecture said, don't stare and get weird. You know, share the love with the eye contact in a natural way, as if you're talking individually to several people at the same time. What else do I have? Where to go, purposeful movement. Professor Cialino also mentioned that. Don't just move because you think, okay, I've been static for 30 seconds, it's time to move, and it's almost like you're on a track, you're just moving. It's affected behavior, right? It's contrived, it just doesn't look natural. You move with a purpose. It might be to signal a transition from one thing to the next, or it might be to emphasize a certain point. Purposeful movement. What to do with your hands. I'm going to be a little bit less structured than what Professor Cialino told you. Remember, generally keep them within the box, but use them within the box being right here, right? Like a strike zone. Don't flail your arms all over the place. I think that is a good way to look at it, but I'm also going to add to that, do what comes naturally, right? If you're from New York, in certain neighborhoods in New York, you're going to use your hands, and it's going to look natural, and it's going to be your way of expressing yourself, right? So don't be afraid to do what comes naturally. You know, you don't want, I love this, the fig leaf pose. I call it the Star Trek pose. You saw Beto O'Rourke at one of the debates? He started out like this. He lost me right there. When some speechwriter, some consultant told him, this connotes confidence and control. This just looks weird. Right? You don't stand in front of a jury like this. And you see a lot of, you know, in the presidential debates. That's a perfect example. This is sort of best practices amongst consultants. It's deadly to have an unnatural manual pose, or with your hands behind your back. People don't stand like that. They don't talk like that. So do what comes natural. Okay, I'm really pushing the envelope here with you all. It's 6:50, but principle number 7, keep it as short and reasonable in the circumstances. There's no magic line. It's not 10 minutes, 12 minutes, 20 minutes. It really varies from case to case. It depends on what you need to say. But generally, try to keep it as short as possible. The attention span is not going to be very helpful with most jurors, right? So you want to keep, they'll let you know. They'll start fidgeting, they'll start rolling their eyes, or they'll start doing what some of you are doing right now because it's time to get out of this class, right? So movement here and there, right? I get the message. You get the message if your opening statement is too long. Right? So just keep that in mind. I mean, 20 minutes, 30 minutes, once you get past 30 minutes, it's got to be one hell of a story to keep them interested. Okay? So, y'all got to get started, if you haven't already, getting ready for your opening statements. You know whose side you want, plaintiff or defendant. That's Monday. Monday you're going to be giving an opening statement. We don't expect it to be perfect, and we don't expect it to cover all the bases, but the rudimentary elements, the components of your case, keep in mind some of these things that we've been talking about. Sorry if I went a little too fast. But yeah, I'm sorry, you had anything else?